So now we move to a much more complicated case. Let me skip to it in my notes because the notes are out of order. So, parents involved. This is a 5-4 decision, 2007. Justice Roberts is on the court. He writes the majority opinion. When I first started teaching this section, or started teaching desegregation, I didn't have to teach. I literally stopped at Freeman because that was the last case. And now we have parents involved. So some facts behind the background. Seattle, which had absolutely never been under a desegregation order. There was never any district court control. It had never operated legally segregated schools. Decided to make a system that actually incorporated racial identity in terms of school choice. So it classified students as white and non-white and used it as a tiebreaker to allocate slots to popular high schools. It was the second tiebreaker. The first tiebreaker was if a sibling attended the high school. So the second tiebreaker was basically racial identity, whether you were white or non-white. There was another case that sort of joined this case that wasn't Seattle. That was from Jefferson County, Kentucky. It had been under a desegregation order from 1973 to the year 2000. And 2000, the district court released the district from supervision. And after being released, the school district decided to classify kids as Black or other in order to keep its magnet schools at between 15 to 50% Black. So it wanted to keep its strongest high schools to have a percentage of African-American students. So what both of these school systems have in common is that they're making determinations on who can attend what school, at least partially, on the basis of race and ethnicity. So the determining factor in both of these school districts is race. Now, the goal of that was to increase diversity within these systems. So the issue in this case is, can a public school that had not operated legally segregated schools choose to classify students by race in order to make public school assignments? And the answer that the majority of the court says is absolutely not. No, you can't do that because it's a violation of the 14th Amendment Equal Protection Clause, which, if you remember, that's literally what the constitutional linchpin is in all of the cases beforehand. It's the 14th Amendment Equal Protection Clause. And here it's being used to say, no, you can't classify students on the basis of race in order to make school assignments, which, think about the factual setup differently. Let's say instead of for the means of diversity, which was the end of these systems, they wanted to be as diverse as possible. Let's say it was actually to segregate. And so you're using race and ethnicity and that identity as a mean to assign students to an overwhelmingly white school and an overwhelmingly African-American school, and you're doing it on purpose. That's a violation of the Equal Protection Clause, and we know that as far back as Brown. Well, if you change the reason from segregating school systems to increasing diversity in school systems, the court is now saying in 2007 that that also is a violation of the Equal Protection Clause. So it's consistent, but the goals of the schools are very different. So we know that strict scrutiny has to apply to any sort of case that deals with a racial classification. And when you have strict scrutiny applying to any case that deals with racial classification, you have to, the state has to demonstrate that it has a compelling interest to make that classification. That's a really high bar for courts to, for any sort of government to meet, a compelling interest. So in this case, we know what the compelling interest. The compelling interest is diversity. That if we agree with the opinion of Brown, the writing in Brown that says that there is value to be gained about having a diverse student body, or to have, typically segregated races together. If we agree with that, then diversity as a goal complies with Brown. And here, since that diversity was a determinative factor, that diversity itself made the choice, the court says that no, diversity itself cannot be the reason why one student gets in over another. That it might be something you can take into account, but the systems as they were designed, so the second tiebreaker being whether you were white or non-white, or looking at the percentage of the school and going, well, we need more African Americans in the school to balance out what we want, that those choices that are made exclusively on the basis of race and ethnicity does violate the 14th Amendment. So Roberts writes in the majority opinion, he actually quotes Brown too, and says that for schools that never segregated on the basis of race, the way to achieve a system of determining admissions to the public schools on a non-racial basis is to stop assigning students on a racial basis. So Brown 2, for Chief Justice Roberts, is if you want to make sure you're not ever going to make decisions on the basis of race, stop assigning individuals an identity based on race and then making decisions based on it. Justice Thomas concurs, but his concurrence is not, it's as conservative as one would expect Justice Thomas to be. Justice Thomas concurs and says that student body diversity is not actually a compelling state interest. He cites conflicting social science evidence regarding diversity in education. As someone who has written on diversity in higher education, I can tell you factually that Justice Thomas is wrong. If there's a question about whether student body diversity is a compelling interest, that's a legal question. But if the reason you're making that decision is based upon, quote unquote, the conflicting social science evidence, that's just not true. There isn't conflicting evidence. So Justice Thomas appears a little off base. Justice Kennedy also concurs in part. So he concurs separately because he feels that at times, race and ethnicity can be taken into account. Because schools may want to ensure equal opportunity for all, and you can find solutions by using race as a means to solve the objectives of Brown. So he concurs in the outcome in this case because he felt that these decisions based solely on race were too far, but he thinks that race can be taken into account. And if we were to do more affirmative action cases in this section, which we don't for just brevity and time's sake, you would see that Kennedy does sort of vacillate back and forth in this area. He's not very consistent. This isn't Justice Kennedy on gay rights, where he is consistent in every decision he makes. He sort of vacillates in terms of whether race can be considered in terms of assignment. So Justice Stevens dissents. He says the Chief Justice's opinion that relies on Brown actually misreads the history of racial discrimination in public schools in the US. Basically, he says that the Chief Justice doesn't understand what Brown was about. Stevens, ironically, was one of the conservative judges that Nixon appointed to the court during the area of retrenchment from integration. And he writes that the Chief Justice doesn't understand racial discrimination in public schools in the United States. And he might have at least a little bit of a point, considering he was on the court during the time that many of these cases were handing down, but we should note, wasn't always on the liberal side in those cases. Breyer perhaps has the most firebrand dissent, if you will. writing that integration remains the goal under Brown and Swan, particularly in school districts like Seattle and Kentucky that had segregated schools. So Breyer, despite Freeman, pulls back in integration, says integration is the goal and using race as a decision in integration is important. Now remember, Kentucky did have a history of segregated schools, Seattle didn't, at least legally segregated. And there's definitely a de facto question about the segregation of Seattle schools, but certainly there was no legal based discrimination. So he argues that the use of race to encourage racial integration is constitutional under the Equal Protection Clause. So that using race as a means to encourage racial discrimination, that's fine under the Equal Protection Clause. That's really, at least for public schools, not higher education. That's really the last Supreme Court decision we have in this area. So this is where we would sort of put a bookend on racial discrimination cases in public education at the below higher education level for this class. So are there any questions in terms of wrapping it all up or the parents involved case particularly?